So let's get into Luigi Mangione. Now, as you probably all know, it's so funny in the world of this true crime stuff. As I'm trying to become more and more of a cutting edge on Brian Koberger and Luigi Mangione, I realize that I'm so 8 hours ago. It's so frustrating when I'm on vacation and I'm literally on flights from Seattle to Las Vegas as I was this morning, and I can't go and respond to the cutting news, and people are asking me to comment on it, and I'm like, if I wait 5 days, it's all old hat. Everything that I have to say now will be like, dude, people have been saying that for a week now. It feels so weird. Other than this weird vacation, because normally I have nothing to do. This family vacation is completely out of the norm, right? Completely out of the norm. And it's probably the last vacation I'm going to do. So I'm going to have time to be more on top of it. But this 5-day window where I'm going to be watching a lot of Vegas shows, by the way, and so I won't be able to be here. Like, even if I want to, I cannot be here. I literally will be in some Vegas shows, watching some Vegas shows. But I want to talk about the omnibus pretrial motion for relief that was submitted. I believe it was submitted on the 11th, which was yesterday. I'm so behind the time talking about yesterday's thing. But there's a lot of stuff I want to talk about Luigi Mangione. First, I want to start out by saying this. Recall, for those of you who are following Luigi Mangione, that Luigi Mangione supposedly has a confession letter to the feds, basically telling the feds that he appreciates what they do. He also allegedly had a manifesto in his possession where he talks about why he did the things that he did. These things and this confession letter and manifesto essentially indicate that Luigi Mangione was waiting in Altoona, Pennsylvania to be arrested because he was giving himself up. He was ready to confess. He had the weapon with him, right? That's what we've been told. He had the weapon with him. He had a confession letter with him. He had a notebook with everything. He admitted right away that he acted alone. All these things came out that suggest that Luigi Mangione has no problems and intended to be arrested. That is not true. That is not true. I'll tell you why it's not true. The last two motions from Thomas Dickey, his attorney in Pennsylvania, let me point something out I have said before. Thomas Dickey cannot speak on behalf of his client, something that his client does not wish him to do. So if his client comes forward and says, now comes Luigi Mangione, defendant, through his attorney, Thomas Dickey, you can be assured that is something Luigi Mangione wants his attorney to say. So please get rid of this BS idea that Luigi Mangione basically wants to confess, but his attorney is fighting it for him against his wishes. That is not how things work. That is unethical. His attorney cannot make the motions that he's making right now without Luigi Mangione himself approving. So you've got a problem now. You've got a problem, which is that you've got this idea that Luigi Mangione confessed already. He had a manifesto. He confessed to the feds. He gave up all the information. He sat in that McDonald's to be arrested. Why are we even having this discussion? That can't be true. That can't be true. And this is what the pretrial motion, the omnibus pretrial motion for relief shows us. Thomas Dickey is saying, basically the legal wording is this: my client is asking that you quash all of the illegal search and seizure. You quash his statements that suggest that he gave a confession. You quash all of the items that you provided. He did not, by the way, violate the law by handing an illegal driver's license to Altoona Police Department. That was not illegal. We've talked about this before in my live. If you haven't seen it before, I've got recordings explaining why. It was not illegal in Pennsylvania for Luigi Mangione to provide an ID of Mark Rosario. That was not illegal. Everybody says, how can it not be illegal? You can't provide false identification to a law officer. Yes, you can in Pennsylvania if you have not been informed that you are under investigation. Luigi Mangione clearly was not informed that he was under investigation for at least 20 minutes. We're gonna cover that because again, it comes up again in Thomas Dickey's pretrial motion for relief, as he points out just how long it was before Luigi Mangione was actually officially told that he was under investigation for anything. We're also now being corrected in this new pretrial omnibus motion for relief. He is making it clear details that we didn't have before. Again, let me point this out to you. So originally, just not too long ago, we did a live talking about how the Altoona Police Department indicated the entire reason that they came to Altoona, Pennsylvania to investigate, although Be careful. Altoona said they didn't come there to investigate him because that would be basically, they would have to inform him as under investigation. They came there because somebody reported that McDonald's said he had outworn his stay at McDonald's. That was not true. Let me cover, God, there's so much to cover, people. So much to cover. Okay, so in a press release, the police officers went and told people that they were called to McDonald's because someone matched a description of the shooter in New York City. This is contrary to what they told him when they came to arrest him, essentially later, which was that they came only because someone reported somebody suspicious sitting in there and that he had outworn his welcome at McDonald's. This is critical because according to the defense, if he was under investigation for the shooting or being the suspect in the shooting in New York or looking like the suspect in New York, they needed to inform him of that he was under investigation for that. They did no such thing. They did, in fact, new details came out. This is amazing. New details come out in this pretrial motion for relief that indicates exactly what they were doing versus what they said they were doing. They originally said, we're just coming here because someone said you look suspicious. That's it. He wasn't under investigation. In fact, Luigi Mangione was told, we're going to cover it again here in a minute. He was told, you're not under investigation, which, as Thomas Dickey said, is completely contrary to the facts in the matter. He was under investigation. And he's got proof that Luigi Mangione was under investigation, even though they lied to him. The Altoona police officers lied to him and said, you are not under investigation, which is a lie. He's got in this document when Altoona came to him because he was under investigation and lied to him and said he was not under investigation. That's a violation of his constitutional rights. He must be informed he's under investigation. All right. I'm getting ahead of myself because I'm so spun up about how bad this document is. Since we got a great number of people here now, we got a 7.9K fall, likes. This is a great start. 43 concurrent. Let's get into the details of this because I really, really want to hash this while we're going hot. Okay, comes now Luigi Mangione, defendant above named through his attorney Thomas Dickey. This is again from March 11th. This was yesterday. So yesterday's news, but we're going to cover this. Basically the defendant, the petitioner herein is restrained of his liberty, instant charges, inasmuch as bail was denied. Now, the very first item is that bail wasn't granted to Luigi Mangione. This was a problem. They should have granted him bail. So basically, right off the bat, they're saying, inasmuch his bail was denied, this was a problem. They list Magistrate District Judge Benjamin Frederick Jones of the Judicial District, who basically did not give a bail option to Luigi Mangione. That's a problem. That's point number one. Problem number one, you should have granted him bail. You didn't grant him bail. That's bullshit. All right. That's not even the meat. That's not the meat. That's how it starts. We're going to go point 5 into this document. I highlighted a bunch of stuff, so we're going to skip that down to the meatiest of the meatiest stuff that we can cover tonight. Number 5, the defendant believes that the instant charges are not supported by the prima facie case, so that the petitioner's detention and confinement on the instant charges is illegal. What that basically means is you did not have enough evidence when you came here to do what you did to make a detention. You did not legally have a reason to detain me, and so therefore the fact that you did detain Luigi Mangione is a problem from the get-go. You did not have enough prima facie. You did not have enough evidence on the surface. At first look, there was not enough for you to be able to detain and curtail his civil liberties and put him under investigation and interrogation for 20 minutes before he was informed that he was under investigation. So 20 minutes they detained and curtailed his civil liberties without informing him that he was under investigation, and there was not enough prima facie surface evidence to detain him in such manner. Again, this is getting very legal, but I think it's going to become more clear as we work through this document. Number 6, the petitioner further avers that the evidence seized, obtained, or in possession of law enforcement and or the Commonwealth, purportedly in support of any instant charges, was obtained illegally and unlawfully for reasons set forth, and it lists reasons. Now stop for a minute. Stop. I want you to understand this. Luigi Mangione cannot both decide to confess that he's the guy who did these things, and here's my confession letter, and here's my manifesto, and here's the gun, and here's all the shit, and I'm ready to be arrested because I did it, and I'm confessing to it all, and also come here through his attorney and say, that all was bullshit, you can't arrest me. You had no reason to arrest me. This, again, cannot be done against Luigi Mangione's wishes. If his attorney is saying, Luigi Mangione wants you to throw out the entire arrest as being illegal, That means he wants you to throw out the entire arrest as being illegal. So it flies in contradiction to the confession idea that Luigi Mangione was ready to confess, had a confession letter, and said, here, take me to jail, I'm ready to go. That can't be true by what we're seeing, because Luigi Mangione is asking through his attorney to throw out the entire arrest warrant, to the entire arrest as being completely illegal. And therefore, everything that happened, including the confession, supposedly, and the manifesto, all of that is illegal. You can't use it. It's an interesting tactic. Pursuant to PA.R.Crim.P.108A, this is a specific document cited in here. The venue for this petition for writ of habeas corpus, which challenges the legality of the petitioner's detention or confinement in a criminal matter on the grounds of insufficient evidence of prima facie case. It's again saying you didn't have enough evidence to detain me when you detained me on the surface. There was not enough surface information to make that detention. You illegally detained Luigi Mangione, and you did not have enough information at the start. Now, they later, through interrogation, through taking his driver's license, through sending photos to the FBI while he's detained and double checking things, that all comes out in this document. While they're continuing to dig deeper, they end up getting something to arrest him on. But on the prima facie case, the surface level stuff that they had no reason to detain him. It was only after he was already detained and they continued to dig and dig and dig that they then come up with a reason to arrest him. You can't do that. That's a violation of his constitutional rights. They stated over and over and over again the violation of the U.S. Constitution and the Pennsylvania Constitution over and over again. If I'm being confusing and you need me to be a little bit more clear, let me know. I'm just going to go through this document, but I feel like even now I'm feeling like some of you may be confused about where this is going. Let's continue on. The defendant prays that the court issue a writ of habeas corpus, basically letting him go, basically from detention from the Pennsylvania, after the requisite proceedings, and grant relief by A, discharging the defendant in the above captioned criminal action. So he wants Luigi Mangione, through his lawyer, wants to be discharged of these charges. Should discharge in whole not be warranted, then quash such charges that are not supported by the prima facie case. So he's saying, if you're not going to let me go, you need to quash all of the shit that you found because it was done illegal. There was no reason to legally detain Luigi Mangione. Therefore, if you're not going to let me go, you have to at least get rid of all the evidence that you collected illegally, because that detention was illegal. And so therefore, again, Luigi Mangione is requesting that he be released. And if not released, all the information that was gathered for him in that investigation, that illegal interrogation and detention and investigation at Altoona Police in Altoona, Pennsylvania, at the McDonald's, all of that needs to be tossed out because it was obtained illegally. And let's go to a motion to suppress evidence, number 11. On or about December 9th, we're getting into the details now. On or about December 9th, 2024, at approximately 9:14 a.m., 2 Altoona police officers were dispatched to McDonald's, located at 407 East Plank Road in Altoona, Pennsylvania, for a suspicious male that resembled the suspect who shot the CEO in New York. He was described as wearing a beanie and medical mask. This is relatively new, in my opinion, information. Before, in just the last motion that was filed, at just the last one, they said that the police officers arrived there because he looked suspicious and had outworn his stay at McDonald's. We know that's not true. We know that behind the scenes, someone supposedly, an anonymous caller, supposedly called in a tip that this man looked like the shooter in New York. Now, again, set aside for a moment that nobody can see from those limited photos that have going around the internet based on the guy who pulled down his mask at the hostel, whether or not that was Luigi or not. There's no way some random person who just calls in and says, hey, I think this is the same guy that's on that video, that footage that we can't see hardly his face at all, but this must be the guy. Let's set all that aside for a moment. The point being is that this document is now telling us specifically that the Altoona police came there because it was called in that he looks like the guy who shot the CEO in New York. Now things are changing. Because now we're being told specifically the reason why they came. It wasn't because he outstayed his stay or outstayed his welcome at McDonald's, that he was loitering because he ate his hash brown for 30 minutes. That is not true. The new statement is you came there because someone told you he was the shooter in the CEO case, or that he resembled the shooter. At no time did the Altoona Police Department during the 20 minutes of interrogation inform him of that he was under investigation or that he was under suspicion of being the shooter in New York? That's a violation of his constitutional rights. He was not informed that he was under investigation. In fact, he was specifically told, and it's stated again here, he was specifically told, you are not under investigation for anything, which is a lie, and that's a problem according to his attorney. You can't lie to him when you know he's under investigation. You were called here because he was under suspicion of being the shooter in New York. You lied to him and told him you're not under investigation. Hey, no, don't worry about it. Let me see your ID. Let me see this. Let me run your photo. Let me do all these things. Check the FBI database. But you're not under investigation. You can continue to talk to us without having us read your Miranda rights, even though you clearly are being detained and under investigation. Number 12. Prior to their interaction with the defendant, no officer of APD personally spoke to any individual who would have provided. Okay, so this is important. Let's slow this down. Number 12. Prior to their interaction with the defendant, no officer of the APD, that's the Altoona Police Department, personally spoke to any individual who may have provided the anonymous or other information to 911. Let's stop there. The paragraph goes on, but let's stop there. What they're saying is Altoona Police Department rushed in to interrogate Luigi Mangione on the anonymous tip that he might be the shooter in the CEO murder, right? At no time did the Altoona Police Department ever look into the person who called that tip in, ask information, verify that there was credible reason to believe so. They don't have enough information to come do the interrogation that they did. The prima facie evidence, what they had, wasn't enough. They didn't even get why do you think this person is the shooter? They didn't even do that. Immediately they rushed in without even checking with the person who called in the tip and start interrogating this guy in the corner, pinning him in the corner, curtailing his right to leave, detaining him effectively, and interrogating him for 20 minutes before placing him under arrest. Now, accordingly, continuing on with number 2, accordingly, APD officers had no independent knowledge regarding the origin, the genesis, or basis of the information, and whether or not this information was reliable or whether it was based on a caller's hunch. Again, this is about the 911 call. What it's saying is Altoona police came there because they were told that this guy might be the shooter in New York. They did not check the source. They didn't go to the 911 caller. They didn't ask under which pretext they believed that. They just started harassing somebody based on hearsay that they didn't even follow up on and said, well, if they say this is the shooter from New York, then that's good enough. That's not how it works. They should have done more research. But no, they didn't. They just came in and they didn't even bother to find out why this person thinks that this is the shooter from New York or potentially the shooter from New York. Let's continue on number 13. Thanks again for the likes. Keep that stuff going if you can. It really helps out. Okay, number 13. Am I going too fast? I'm probably going too fast. But I got to get back to the family who's all out in the other room. I want to be able to visit with people, so I'm going too fast. I know. But I want to get something in the can, so let's do this. Number 13. Prior to their interaction with the defendant, the APD, Altoona Police Department, made no contact with law enforcement authorities in Pennsylvania, New York, or the FBI. To determine whether or not the defendant was in fact the person who is the suspect being sought in the New York shooting. This is new information. Listen up, this is new information, okay? So, prior to the interaction with the defendant, APD didn't even make any attempt to contact the authorities in Pennsylvania, New York, the FBI, or anyone else to see if this in fact was the person who's being suspect in New York shooting. In other words, somebody said it is, so they're rushing in and they're cornering this guy and pinning him in the corner and all over him like ugly on ape, based on no fact checking, no whatsoever. We don't do that. You're not supposed to do that. Yes, this is a lawsuit in the making. Let's continue on. Number 14. The 2 APD police officers who arrived at McDonald's were uniformed, armed, and fully equipped with other police equipment, radios, etc. Said uniforms exhibit badges, patches, and other identifying insignia indicating their identity as police officers. Why is that important? Why are they bringing that up? Because what they're pointing out is no reasonable person would assume that they are free to go. 2 uniformed police officers with guns, badges, the whole 9 yards came and they pinned him in the corner, blocking his ability to leave. Any reasonable person would believe at that point that they were under detention, that they're being detained. However, at no point did they tell him that he was under arrest. This is a big problem. These are legal shenanigans. Here's another thing. thing. Is Luigi Mangione so smart that he knows these things? Did Luigi Mangione set up the Altoona Police Department? Did he know that this was going to provide an illegal arrest and detention? Did Luigi Mangione purposely sit? This is the question you have to ask yourself. Is he just some unsuspecting guy who they cornered, who literally they cornered and pinned in the corner and illegally interrogated until they could find something to pin him with? Or was Luigi Mangione purposely doing something that he knew was going to lead to an illegal detention? Did he sit himself in the corner because he knew the officers would pin him in the corner and that he'd be able to throw everything out? Because that's the big kicker, right? It's like, not only do you have all the information, but you can't use any of it because you did it illegally. Was that something? Is that something that you can entertain the possibility that Luigi Mangione could have done? Again, this leads to the question of whether or not you think Luigi Mangione is 100% innocent and is just an innocent guy being fingered for something. And I realize some people don't like that word, fingered. I get it. But the point being is he just an innocent guy being set up and he had nothing to do with it? Or did he do something and he's a step ahead of the law enforcement? Did he think this through? Is he really playing games with police? The reason why I say that there's a potential for playing games is I got a long form video on YouTube called The Game Theory, Luigi Mangione, The Game Theory. It talks about whether a group of computer game theorists had designed a game, that they're literally playing a game with law enforcement. Did Luigi Mangione, this is something I have to ask as the devil's advocate, did these people know that they were going to lure the police department and FBI into making mistakes and they were going to basically bag the entire case? Now, the problem, that's a huge risk if that's the case, right? It's a huge risk. We're going to get back to this omnibus. We're not even a quarter of the way through this omnibus pretrial hearing for motion for release, but we're going to get back to that. But the point being is that it's a big risk because, again, they want Luigi Mangione so bad that I can't imagine they're ever going to let him go. So if you're relying on, you made an illegal arrest and I'm going to walk, if that was the case, you're relying on them playing by the rules. They already aren't playing by the rules. They're going to keep you in jail, right? No matter what. It doesn't matter how many violations of your constitutional rights that you did. They did. They're never going to let you out, right? And if you keep pushing it, unfortunately for Luigi Mangione, it could lead to a horrible situation where he has an accident or a guilty remorse, and they'll be telling us all that something happened that didn't happen. I'm getting way ahead of myself. I sound like a nutbag, don't I? I sound like a nutbag. You guys are like, where the fuck is that guy going with that stuff? All right, let me move on. All right. Let's continue on to step 15, or point 15. The defendant's only natural path of travel other than climbing over the dining table and or route of egress was to his right. This would require only the slight movement of an unoccupied chair to the right. The point being is that they're pointing out again, as they did in the last, as Thomas Dickey pointed out in his last pretrial motion, was basically they detained him and there's no way Luigi could have gotten out of the corner without literally pushing police officers out of the way. And if he pushes police officers out of the way, as I've told you over and over again, that's going to be an assault all day long. And they would have slammed him and said that he assaulted an officer, and you'd all believe that he somehow assaulted an officer, when really all they did was they blocked him. And if he tried to get out and even so much as touched an officer in his attempt to get out of the corner where they had him pinned, they would have claimed that Luigi Mangione assaulted him. But you know what Luigi Mangione did? He sat and he obeyed all the commands, including putting his hands above his head, letting them frisk him illegally, search him, take his belongings illegally, separate him from his belongings illegally. He did all those things without fighting them whatsoever, even though he could have tried to, because they said, hey, you're not being detained. You're free to go anytime you want. And if he had pushed past them, he would have assaulted them, but he didn't do that. All right, let's continue on. Number 16, upon their arrival, one APD officer, Altoona Police Department officer, immediately posted himself to the defendant's immediate right and within arm's length of the defendant. Now, this is language straight out of the last omnibus pretrial hearing motion, but this is being repeated again with additional details. Blocking his only path of natural travel and or egress. The other APD officer positioned himself directly on the other side of the table, forming a human law enforcement wall blocking the defendant. Had the defendant decided to leave the dining area, he would have been required to penetrate through and or physically push aside two uniformed and armed officers. No reasonable person or in the defendant's position would believe that he was free to leave. Again, if this is more clearly worded by Thomas Dickey saying the same thing I said. If Luigi Mangione touched one of those officers, he would have literally had to have pushed the officer out of the way, and that would have been assault, and they would have had his ass. But he didn't do that. Thank goodness for him. They didn't do that. Number 17, the aforementioned actions by APD officers constituted a seizure and, at a minimum, an investigatory detention of the defendant. So, in other words, he's effectively detained, because if he were to touch them, they would say he assaulted them. So he's detained. They can only say, hey, you're free to go, if he literally has a path to leave without touching an officer and assaulting an officer. But they made it so that he would have to assault an officer. They were setting him up, in my opinion. They were setting him up to assault an officer. That's what they wanted on the news, that Luigi Mangione assaulted them. And if that had happened, we probably would see the body cam footage that nobody has seen. Ever thought about that? We don't get to see the body cam footage of the arrest. But I bet you dollars to donuts, if Luigi Mangione had pushed one of the officers and assaulted him, we would have saw that all day long, right? But what they don't want to see is they don't want you to see them badgering him in the corner, a defenseless man, not doing anything, not touching them, not assaulting them, and them continuing to be like, we got to get something, man. Put your hands on your head, do this, but bark, move. They don't want you to see that. They don't want you to see that. So it would have gone down differently had Luigi tried to actually exercise his freedom to leave. All right. This is number 19. The combined actions of the two APD officers were designed not only to exhibit their authority and control over the defendant, but also to restrict and totally curtail his liberty. These actions resulted in a stop, arrest, seizure, and investigatory detention of the defendant. At that time of the stop, arrest, seizure, and investigatory detention of the defendant, the APD lacked reasonable suspicion to engage in such activity. In other words, he has been arrested, he has been seized, he is under interrogation, and there was no prima facie, no good evidence supporting them doing that. 100% illegal. I hope I can hit this enough. 100% illegal. Said actions are, and it continues, said actions are a violation of the protections afforded to the defendant under the 4th Amendment of the United States, the 14th Amendment of the United States Constitution, and Article 1, Section 8 of the Pennsylvania Constitution. All right, number 20. And thank you again, everybody. Thank you so much for taking your time and letting me take some time out of my little family vacation in Vegas to share this with you. Step number 20. Prior to this stop, arrest, seizure, and or detention of the defendant, the APD officers had no articulable facts and observations, no criminal conduct on the part of the defendant, nor any evidence indicating that any criminal activity was afoot. In other words, they're just stating over and over again, you are detaining him and you have nothing to detain him with. Accordingly, APD lacked reasonable suspicion to engage in this activity. In other words, they have no basis for interrogating him. They have none. So they lacked reasonable suspicion to engage in this activity. At no time did the defendant exhibit any threatening gesture, any show of force. These actions by APD were in violation of the protections afforded to the defendant under the 4th Amendment, 14th Amendment of the United States Constitution, and Article 1, Section 8 of the Pennsylvania Constitution. Again, stating all the things they violated. He didn't assault an officer. He was completely compliant, and he was illegally detained. They did not have anything to go on at that point. They were literally on a fishing expedition. You can't just come interrogate somebody to death on a fishing expedition until you find them tripping up on something that you can arrest them on. That's not how it works in our country. Step number 21. Other than the anonymous 911 call, the APD had no independent corroborating evidence that the defendant was in fact the suspect sought in New York prior to or at the time of their stop and or the investigatory detention of the defendant. Again, they had no evidence whatsoever that he was the person who was being suspect in New York. And yet they came there because they suspected him of being the guy, even when they had nothing to link him to the shooting in New York. They just had a gut hunch. They had a hunch. That's what it says here multiple times. The officers merely had a hunch. That is not legal. You can't just go harass someone on the street because you have a hunch. You have to have evidence. You have to have a reasonable use to do this. This was not reasonable. That's what the argument is about. Number 22, APD, prior to or at the time of the stop in the investigation or detention of the defendant, had no paperwork, no photograph, no warrant, communication, or other information in his possession corroborating that the speculation that the defendant was in fact the person being sought in New York. Again, clear indication of things they don't have. They don't have paperwork. They don't have a photograph. They don't have a warrant. They don't have communication. They don't have anything to link him to New York other than a gut hunch that he might be the guy from New York. Step 23. Prior to the stop, arrest, seizure of the investigatory detention of the defendant, APD officers had no objective grounds for said detention other than the hunch or unparticularized suspicion. So in other words, that's not good enough. Thomas Dickey is literally saying you're working on a hunch that is illegal. You can't just go on your hunch and go interrogate and harass somebody because you have a hunch. Number 25. Police must have reasonable suspicion to support an investigatory detention at the moment of detention, according to the 4th Amendment and the 14th Amendment and Article 1, Section 8 of the Pennsylvania Constitution. You must have a reasonable suspicion to conduct an investigatory investigation. They did not have that information. They had no photos. They had no proof. They only had a hunch, and that's illegal. Number 26. At the time of the stop, arrest, seizure, and investigatory detention, APD officers told the defendant that he looked suspicious, in quotes, and gave directions and commands to the defendant to perform certain tasks, including but not limited to providing his identification, standing up, sitting down, placing his hands on his head, as well as a Terry frisk. They also questioned him, this being patted down. They also questioned him about being in New York. At no time did the APD officers indicate that the defendant was free to leave. So he's being detained, he's clearly being interrogated and investigated without being told he's under investigation, and in fact, later will be told, you are not under investigation, which is a complete lie. He clearly is under investigation. They're now telling you over and over again, they came there because they believed he was the person in New York. That means he's under investigation. They're investigating a suspicion that he might be the shooter in New York. They lied to him and said, you are not under investigation. That's not good. You can't do that. Number 27. The totality of the circumstances, including but not limited to the positioning, the demeanor, mannerisms, commands, directives, instructions, and other actions of APD, showed that at the time of the request for identification was made, so when they asked him for his ID, that compliance with this request was required. In other words, at no point did Luigi Mangione have the option to walk away. Again, that's what it's saying. He is being detained. He is being informed by a uniformed police officer with guns and badges that you are going to give me you're going to stand up. You're going to put your hands on top of your head. You're going to be searched and patted down. I need your ID. There is nothing about that entire process that is sans Miranda rights. Nobody's read him his Miranda rights. All of that is a detention and investigation, interrogation by the police department while telling him and lying to him and telling him, you're not under investigation, man. Okay. Let's go to number 28. During the stop, arrest, seizure, and or investigatory detention of the defendant, APD officers demanded and requested that he produce identification. Under the totality of the circumstances, the production of identification was not an act of free will. The Altoona Police Department took possession and control of this identification material presented by the defendant and continued retention of the material, the positioning of law enforcement officers and personnel, and the retention of his identification materials for background check, evidence of criminal activity, and or investigative measures signal to a reasonable person that they are implicitly commanding that person to remain on the scene while doing so. Any identification information was illegally obtained insofar as it was the fruit of an illegal investigatory detention. In other words, of saying that fruit of the poisonous tree. You were not allowed to detain him. You had no purpose to detain him. Therefore, taking his ID while you now do a background and check and investigation and cross-reference and call the FBI and ask for, hey, is this our guy? Is this our guy? All of that is illegal. It's fruit of the poisonous tree. You had no reason to conduct that investigation in the first place. Any identification that was, okay, we already covered that. And it states the violation, again, of his Fourth Amendment, his 14th Amendment, and his Article 1, Section 8 of the Pennsylvania Constitution. Number 29, it is clear that the seizure of a defendant, it is clear that a seizure of the defendant had occurred. The totality of the actions taken by APD officers would have communicated to a reasonable person that the person was not free to decline the officer's request or otherwise terminate the encounter. In other words, Luigi Mangione had no, hey, you've got free will, man. You don't have to talk to us. You can go anytime you want to. That is bullshit. That any reasonable person who would see that, and by the way, we can't see that. We can't see it because they won't release the effing body cam footage. But any reasonable person would assume that they were not free to go. Any reasonable person. And it continues on. Any reasonable person innocent of a crime, of any crime, would have thought that he was being restrained if he had been in the defendant's shoes. Said actions are in violation of Fourth Amendment, 14th Amendment, Article 1, Section 8 of the Pennsylvania Constitution. Step number 30, or point number 30. APD officers lacked reasonable suspicion and or probable cause to not only stop, arrest, seize, and or detain the defendant, but also to conduct the Terry frisk on the defendant. You searched his body. You're telling him he's not under detention, and you're ordering him to put his hands on top of his head and patting him down and searching his body. That is illegal. You can't do that. Even if you try to pull that bullshit maneuver of, we were afraid that he might have something on him that's dangerous. He presented no physical threat. He didn't push past the officers to leave as he was free to do so, which would have been assault. Nothing on Luigi Mangione's part exhibited any overt action of danger, and yet they frisked him as if he was a danger to them. Further, there's no justification to perform the Terry frisk insofar as there existed no factual basis to form a reasonable belief at that time that the defendant may be armed and dangerous. So that's what Thomas Dickey is saying. There's nothing about my client's behavior that suggests he's dangerous. He's not angry. He's not shouting at you. He's not coming at you. He doesn't seem to have something in his pocket that seems to be bulging, and his hands going in his pocket like he's going to pull out a gun. Nothing of the sort. He's literally complying with every single step that you ask him to do. Stand up, put your hands on your head, get patted down. That's not the act of somebody you're afraid of. So doing a Terry frisk because you're afraid that he might be armed and dangerous doesn't fly. None of that flies. All right, continuing on. Again, any identification information was illegally obtained insofar as it was fruit of an illegal investigatory detention, stop, arrest, seizure of the defendant. So Thomas Dickey hits this over and over and over again. Number 33. A member of the Altoona Police Department questioned the defendant about whether or not a backpack, plastic bag, and other items belonged to the defendant. At that time, the Altoona police officer seized the items of packages and placed them in an area behind law enforcement personnel so that several police officers were positioned between the defendant and the seized items. At all times thereafter, Altoona police officers remained stationed between the defendant and the items of property believed to belong to the defendant. These items properly remained in control of the Altoona Police Department throughout. Defendant believes this action further supports his belief that he was not free to go. In other words, and we've said this on the last time, they separated him from his belongings. They took his ID and didn't give it back. They took his backpack and placed it on the opposite wall of a wall of law officers, a human wall of law enforcement, separating him from his belongings while trying to tell him, hey man, you're free to go. You're not being detained and you're not under investigation. But we've got all your shit. Where you can't get to your shit without assaulting a police officer. You can't leave the corner without assaulting a police officer, but you're free to go. So don't ever play this whole I didn't know I was being that I was free, that I was being detained. You were free, you're not free to go. That's the point. You are not free to go. Any reasonable person, this is what Thomas Dickey says over and over again, any reasonable person would know that they are being detained. He was being detained, but yet they'll tell you they did not detain him. Why do they tell you that he's not being detained? Because it was illegal. All right. 35. These 8 to 10, they're talking about additional people, additional officers that are arriving on scene, including a member of the Attorney General's office. These 8 to 10 additional persons, including additional APD officers, as well as agents, not one. Before we were told an agent of the Pennsylvania Attorney General's office had shown up. Now this document's wording has changed. Officers as well as agents, plural, of the Pennsylvania Attorney General's office. These personnel positioned themselves in a manner to block all exits of the McDonald's as well as paths of ingress and egress to other parts of the restaurant. In other words, now everyone's showing up. Everyone's coming to the party. We got our trophy. We got Luigi Mangione. We got him in the corner. I want the Attorney General's office down there taking a photo of this guy and taking a trophy shot, which they did. All right, number 36. In order for the defendant to exit the dining room table to venture to the service area of McDonald's, he would have to have had passed no less than approximately 7 to 10 members of the Altoona Police Department and other law enforcement personnel. At this time, it is believed that there was in excess of 10 law enforcement officers surrounding the defendant in the small dining area. It again became abundantly clear that the defendant's curtailment of liberty, seizure, and unlawful detention and custody continued by this group of law enforcement personnel. No reasonable person would have believed that they were free to leave. The curtailment of the defendant's liberty and his detaining of the defendant at this time was a violation of, guess what? The 4th Amendment, the 14th Amendment of the United States, and Article 1, Section 8 of the Pennsylvania Constitution. Over and over and over again. They're just, you violated his civil liberties. 37, this was, I got this in a different color because it's a different point. This continued unlawful detention continued for approximately 20 minutes. 20 minutes Luigi Mangione was detained and interrogated without being read his Miranda rights. This is a problem. This continued unlawful detention continued for approximately 20 minutes while officers were where efforts were being made to identify the defendant as the New York suspect. So let me repeat that. They're detaining him for 20 minutes, illegally detaining him for 20 minutes, while they're continuing to make efforts to tie him to New York. They're making efforts to identify him as the New York suspect. These efforts included, but are not limited to, sending a photo of the defendant to other off-scene agents of the Pennsylvania Attorney General's office, as well as agents of the Federal Bureau of Investigation. So now they're detaining Luigi Mangione illegally while they're sending his photo off to the FBI, to the Attorney General. Is this a guy? Is this our guy? Is this our guy? Telling Luigi Mangione, you are not under investigation, which is I'm angry. A lie. You are under investigation. They're sending your photo to the FBI while you're being detained illegally. Is this the guy? Is this the guy? Yeah, these statements do not jive. Telling Luigi Mangione you're not under investigation, you're free to leave, any kind of that kind of bullshit while he's being detained and separated from his belongings, and they're having the FBI check his photo, his ID, and saying, is this the guy? Is this the guy? Is this guy? You are under investigation. All right. Attempts were also made to make identification through various facial recognition databases. Again, for the 20 minutes that Luigi Mangione is detained, not only are they sending his photo to the FBI and to the Pennsylvania Attorney General office and presumably NYPD, although they don't list that, but they're also trying to use facial recognition while he's on the scene. Is this the guy? Is this the guy? All of this is illegal. They had nothing but a gut hunch to go on at that point. All of this is illegal. Now, some of you out there, the lay people, are thinking, why is it illegal? I mean, they have the right to question anybody, not in the manner that they did. This is why his attorney is basically throwing a fit. It is against our Constitution. I'm sorry if everybody thinks that police officers can do whatever the fuck they want in this country. They can't. They have to play by the law. They have to play by the rules. They can't violate your Constitution because they just feel like you might be a bad guy. That's not how things work. All right? So, number 38. No official identification of the defendant as being the suspect from New York was ever made by any law enforcement personnel from the state of New York, the Pennsylvania Attorney General's office, or the FBI. Further, no information or responses to the facial recognition requests were received by APD or other law enforcement personnel. Listen to this. Pay attention to what's being said. They're detaining Luigi Mangione illegally for 20 minutes. They're sending off his photo to everyone, and no one can make the connection. No one. And they list who no one is. The state of New York can't make the connection. Pennsylvania Attorney General's office can't make the connection. The FBI can't make the connection. Facial recognition scans can't make the connection. And they're still detaining Luigi Mangione and have to get him arrested. That's a word I can't say on TikTok. All right. Number 39. No name of the suspect wanted in New York shooting, nor any warrant for arrest of any suspect or defendant was provided to the APD, the Altoona Police Department, or other law enforcement personnel by the FBI or the state of New York. Again, they're asking, is this the guy? Is this the guy? And they can't make a connection. They can't make the connection. They can't. There's like, hey, give us reason to arrest this guy. Is this the guy from New York? They can't make the connection on scene. No independent identification or other verification was made nor transmitted by the state of New York or the FBI. That was point number 40. Point 41, any purported identification of the defendant as the person wanted in New York was speculative and based on a hunch. Further, any purported seizure and or detainment in violation of the defendant's rights as protected under the 4th, 14th, and Article 1, Section 8 of Pennsylvania Constitution. So again, they're stating, you could, not only is he being investigated illegally about being the shooter in New York with nothing to go on other than an anonymous phone call from 911 or to 911 or whatever who called it in. Not only did you not follow up on that, you just went in there guns blazing essentially. They didn't pull their guns, so let's be fair with that. But you basically pinned him in the corner and then you interrogated him. You're sending his photo off to everybody. You're saying, make the connection, make the connection. Is this the guy? And nobody can. And you still are interrogating him until you can find something to arrest him on. This is a problem. This is a problem. Another YouTuber that I like. You guys have heard of The Real Nathan Daly? I think he's a former police officer. I love that guy's stuff, right? He also was like, as a former police officer, he's like, this is a real problem. You can't, even as a former police officer, The Real Nathan Daly, like, you can't just go pin somebody in the corner and interrogate them until you got somebody. That's bullshit. A former police officer is telling you that's bullshit. You can't do that. This is all illegal. His attorney knows it. Other cops know it. This is bullshit. Number 42. I'm going to try to get through this. My phone's dying and I got it on charger. My trickle charge is not keeping up. I'm going to have to rush through this. Let's get this done. Throughout the interaction with the defendant, APD officers and other law enforcement personnel continued to detain, interrogate, and question the defendant without any reading of his Miranda rights as required by both the Constitution of the United States as well as the Pennsylvania Constitution. These questions were designed to potentially incriminate the defendant. What are they saying? They're saying, you have the right to remain silent, but you must be told that. Because if you're not told that, you may not realize that what you're saying is going to hang you. He's not actually under investigation. Remember, they told him that. You're not under investigation. They didn't read him his Miranda rights. So he's not informed that, hey, what he's talking about right now may hang him. And they need to tell him that. If he's under investigation for something, he needs to be told that so that he can be told, hey, by the way, you're being looked at as the suspect in the shooting in New York, and anything you say may be held against you in a court of law. So you have the right to remain silent. They didn't do that. They did not. And in fact, as we've stated before and stated again in this document, at the point that the officers remind him that he finally has the right to remain silent, guess what he does? He remains silent. He doesn't say anything more. He shuts the fuck up. So when they remind him that he has the right to remain silent, he does so. But until then, he has the belief, as any reasonable person did, that he has no ability to not communicate and do what the officers tell him. He's being pinned in the corner, surrounded by everybody, including members of the Attorney General's office, getting photo ops, he's the whole 9 yards, and there's no presumption that he can go. He is being detained. Number 42, I don't know if I read this. Let's make sure. Oh yeah, no, that was about the Miranda rights. We did read that. Number 43. The nature, duration, and condition of the investigation, detention by the APD officers and other law enforcement personnel at the time became so coercive as to be the functioning equivalent of an arrest. So in other words, they're all over him with questions and demands, and therefore it is the equivalent of an arrest. It was clear that a custodial detention and interrogation was occurring at this time. This custodial interrogation was performed without probable cause to arrest, stop, seize, or otherwise detain the defendant. And it's a violation. Oh, and the custodial investigation requires the reading of Miranda rights as required by the Fifth Amendment of the United States and Article 1, Section 9 of the Pennsylvania Constitution. So they're just, Thomas Dick is just reminding them, you had the right, you had the requirement, to tell Luigi Mangione that he's under investigation and that he has the right to remain silent so that he doesn't incriminate himself. But you're not telling him that. You're making him talk. You're making him continue to say something until you have something that you can arrest him on. That's not how the law works. And it doesn't, and Michelle, I agree, like, I feel like the average person knows about the right to remain silent. The law in our state, in our country, in the United States, we have repeatedly said, it is not true that a person should just know that they have the right to remain silent. You must be told. You must be informed. We have upheld this ever in this country. You must be informed. It is never assumed that the person should just know better, that they can avoid. Most people, I would counter, and this is not an attack to you, Michelle, so don't take this personally, but this is not an attack to you. Most people in our country are told you have to do what an officer says. You think that if an officer asks you to jump, you have to be like, how high? There's a lot of people who push that, who realize that that is not true. You don't have to bark and kneel and lick the boot of an officer because he asks you to. But there's a lot of presumption in America that you have to. You do not have to. And in fact, they must tell you that you have the right to remain silent. We've upheld this in American politics and in law enforcement forever. They must inform you that you have the right to remain silent. It is not understood by people. This is point 44. In excess of 15 minutes had passed, and the defendant's unlawful detention, seizure, and curtailment of liberty, custody, and interrogation continued. He still had not been given any information as to why he was being held. This continued curtailment of the defendant's liberty, seizure, and unlawful detention is in violation of, and again, the 4th Amendment, the 14th Amendment of the United States Constitution, and Article 1, Section 8 of the Pennsylvania Constitution. Number 46. Let's get to 46. I'm trying to get through this all, okay? So finally, after approximately 15 minutes of the defendant's unlawful detention, seizure, and continued custody, he was advised by Officer Detweiler that he was officially under police investigation. So we've got, at one point, they said they detained him for 20 minutes, but at least under 15 minutes of rigorous interrogation, including taking his ID and running it through databases, sending it to the FBI, doing facial recognition. While all that's going on, he is effectively detained as any reasonable person in the world would assume. Then he's finally told by Officer Detweiler of the Altoona Police Department that he's officially under police investigation. He was not then read his Miranda rights at that time. So now they're literally telling him, you're under investigation as being the shooter from New York, and he still isn't read his Miranda rights. Still is not. So all right. Defendant was then asked who he was. So after they did not read him his Miranda rights, but Detweiler says, hey, by the way, you're now officially, after 15 minutes of being interrogated and standing up and being frisked, you're officially under investigation for something. He's still not read his Miranda rights. And then it says, the defendant was asked who he was, at which time the defendant replied that he was Luigi Mangione. He was further interrogated by members of the Altoona Police Department. So he's continued to be interrogated. So keep in mind, he's given them an ID. They asked for his ID, and he gave them an ID, presumably of Mark Rosario, which is not his name. Again, I will briefly state, because we hit it a lot at the beginning of this thing. By the way, I'm going to have this recorded and published on YouTube so you can watch it over again if you missed the earlier part. It was not illegal for Luigi Mangione to provide a false identification to law enforcement. Why? Because in Pennsylvania, it is not illegal to provide false identification to a law officer if you have not been informed that you're under investigation. Okay? So I'll say that again. It is not illegal for him to do so. And it wasn't until they said, what is your name? And he's like, I'm Luigi Mangione. They're like, oh, well, then you gave us a false ID. You're under arrest. No, because it's not illegal to provide an officer a false ID unless you've been informed you're under investigation. And they clearly did not, until 15 minutes after rigorous investigation, tell him that he was under investigation. Sorry about that. I had a live check from TikTok to prove that I was that I'm really here. Okay, continue on. Number 47. After approximately 2 more minutes of interrogation, so 15 minutes go by before he's told he's under investigation, right? 2 more minutes, or 15 minutes go by before he's told that he's under investigation. No Miranda rights being read. 2 more additional minutes go by, so now we've got 17 minutes of interrogation by the Altoona Police Department before they read him his Miranda rights. At the conclusion of the reading of said Miranda rights, the defendant was asked if he wishes to speak to the police, at which time the defendant shook his head no. Officer Fox immediately stated to the defendant that you're not in custody. Now let me break this bullshit down for you. Okay, so Luigi Mangione's never read his Miranda rights while he's completely under interrogation and detention against his civil liberties. At the point that they read him his rights, they ask him, hey, now that you know you have the right to remain silent, do you wish to speak to us? And not only does he not say no, he shakes his head. Like he's literally not speaking to them anymore. At the point that they say, hey, you don't have to speak to us, he shakes his head. No, I don't want to talk to you anymore. They're fucked. All right. And then they tell him, hey, you're not in custody. Why are they telling him he's not in custody? Why are they telling him he's not in custody? You know why they're telling him he's not in custody. Because they're trying to say, hey, you can talk to us. It's not like you're not being detained. You're not in custody. Relax. Just talk to us. Even though they just told him this is a problem. You can't tell somebody they're not under investigation, then tell them they're under investigation, then tell them that they're not being detained, but they have been detained. The whole thing is bullshit. And that's what Thomas Sticky is basically trying to crucify them on, is that the whole thing was bullshit. And the question is, did Luigi Mangione know they were going to make this mistake? Or is he completely an innocent guy and he just didn't know that he had the right to remain silent? So that's the other question. Does Luigi Mangione know that he has the right to remain silent before they told him? Or did he literally go, oh, I have the right to remain silent? Well, then I guess I'm just going to shake my head. I don't know. We don't know. And neither do they. Okay, number 48. This statement was materially false. Okay, so this statement, what is this statement? What the statement was made. The defendant was told, you're not in custody. Point 48. That statement is materially false, inaccurate, and contrary to the law. It is clear at this time that the defendant has in fact been in custody, or was in fact in custody, and had in fact been in custody since his illegal and unlawful seizure, detention, and curtailment of his liberty. Again, in violation of the 14th Amendments of the United States Constitution and Article 1, Section 8 of the Pennsylvania Constitution. New point in yellow, so I must have highlighted this because I wanted to hit this heavy. Point 49, after the defendant shook his head no, indicating that he did not want to talk to the police, after he shook his head no, the Altoona Police Department continued to question and interrogate him anyway. For fuck's sake, man. Anyone in the world watches U.S. law, right? Anyone at the point that someone lawyers up or says they don't want to talk to police, the interrogation is over. Okay, if you don't want to talk, interrogation is over. Hey, do you want to talk to us? No. Okay, we're going to keep asking you questions. That interrogation should have been over when he said, I don't want to talk to police anymore. After shaking his head no, indicating he didn't want to talk to the police, the APD continued to question and interrogate him anyway, and he was subject to another Terry frisk, a second pat down. He has a second pat down. Okay? So he was then placed in handcuffs and informed that he was being detained. So now you don't want to talk to us? Then fuck you. Yeah, you're detained, right? Okay, we're going to take you in now. For reasons stated, infra, it is the defendant's position that he had already been illegally seized, detained, arrested, and in custody, contrary to the protections provided by, guess what? The 14th Amendment to the United States Constitution and Article 1, Section 8 of Pennsylvania Constitution. Okay, so again, keep in mind this point. Luigi Mangione cannot both have been waiting in Altoona, Pennsylvania to be arrested with a confession letter saying, hey, I'm the one that did it and I acted alone, and also asking his attorney to say, hey, I want all this tossed out. It was an illegal search and seizure. Did Luigi want to get caught or did he not want to get caught? Which one is it? His attorney cannot be arguing all of this shit needs to be thrown out because he was illegally detained. He cannot do that if Luigi doesn't approve it. So Luigi is in agreement with him. My civil liberties were violated, and I want all of this shit tossed out. That is contrary to, hey, I did it, I acted alone, I'm your only guy, take me in and arrest me. These two stories don't jive. All right. Then, get this. A photograph was then taken of him, Luigi Mangione. A photograph was then taken of him by an agent of the Pennsylvania Office of Attorney General. This is what I call the trophy shot. Look at me, I got Luigi Mangione. So this is going to go up on his wall, right? It's going to go on his desk. He's going to be like, oh yeah, hey kids, look at this. I got Luigi Mangione. I was there that day. I got a picture of him. Check this out. So photographs taken of Luigi Mangione at the scene by the Pennsylvania Office of Attorney General, and members of Altoona Police Department continued to interrogate the defendant despite the indications by the defendant that he did not wish to speak in law enforcement. Oh my God, they're still interrogating him after he's told them that he did not want to talk to law enforcement. This is bullshit. Bullshit. He's already told you he doesn't want to speak to law enforcement, and you're continuing to interrogate him and put him in front of a freaking trophy shot. Hey, let's get a picture of Luigi Mangione. We got him. Step 50, or point 50. At approximately 7 minutes later, defendant was physically removed from the McDonald's due to, according to police records, being placed under arrest and taken into custody for the crime of providing false identification to law enforcement and transported to the Altoona Police Department. Said arrest is illegal and unlawful at this time, insofar as the defendant Listen to this. The defendant did not commit the crime of false identification to a law enforcement officer in violation of, and they state the law. Why? Because if you read that law, as I've done on a previous live, and you can go to my YouTube channel and watch the discussion, I'll read you the case law. I'll even read you where the Supreme Court upheld it on a very specific case when a woman was, I think it was a woman, was pulled over by police with sirens and didn't tell her she was under investigation, and she walked because they didn't inform her that she was investigated. And providing false identification to a police officer when you have not been informed you're under investigation is not illegal in the state of Pennsylvania. So that's why Thomas Dickey says that Luigi Mangione did not violate a law and provide false identification. Again, let's be technical about this. Did Luigi Mangione provide false identification? Possibly. Possibly that Mark Rosario ID was false identification. Was that illegal? No, it was not. No, it's not. By Pennsylvania law, providing false identification, a false ID, a fake ID to law enforcement is not illegal. Is not illegal unless you have been informed or under investigation, which the whole argument of this is that he was not informed he was under investigation. Step number 51. Any arrest of the defendant at that time was illegal, and or any charges alleged against him is based on evidence received as fruit of an illegal stop, or in other words, fruit of the poisonous tree. So it's fruit of an illegal stop, seizure, detention, and or arrest. All actions of law enforcement personnel on that date being both singularly and collectively in violation of the defendant's rights and protections by the 14th Amendment of the United States and Article 1, Section 8 of the Pennsylvania Constitution. Oh my God, I think I'm over halfway through this document, but I've been going so fast. I'm now down to 22% battery. I'm hanging on by a thin thread, people. I'm trying to get this finished up. Thank you, by the way, for a really awesome night. 38 or 31.18K likes. That's great for me. 75, that's great for our channel. So I thank you so much for supporting this and listening to me ramble at 1,000,000 miles an hour. Let me try to get through as much as I can before the battery dies or I have to go. All right, number 52. At the same time, members of the Altoona Police Department commenced a thorough search of the defendant. At the same time, members of the Altoona Police Department commenced a thorough search of the defendant's backpack and other items while at McDonald's. The defendant avers that this search and seizure was illegal and unlawful insofar as the same was undertaken without a warrant and subsequent to an unlawful arrest, all being in violation of the prosecutions afforded by the 4th Amendment, 14th Amendment, and Article 1, Section 8 of the Pennsylvania Constitution. So again, they're doing illegal search and seizure, which is saying that because they didn't have a reason to arrest him, they also don't have a reason to illegally search without a warrant his possessions. It gets worse. During the search, this is point 53, it gets worse. Point 53, during the search of the backpack, Altoona police uncovered a clip wrapped in underwear and other items. Contained within that backpack was a separate package secured by duct tape. Said package was opened via removal of the duct tape with a knife by a member of Altoona Police Department without a valid search warrant and without other legal justification. The said package contained a computer chip. Defendant avers that such a search and seizure was illegal and unlawful and a violation of their 4th, their 14th, and the Article 1, Section 8 of the Pennsylvania Constitution. Not only did they illegally search and seize the backpack, but they went even further into an item that was wrapped in duct tape and used a knife to cut it open in violation. You have to have a search warrant. You would have to have had a search warrant for the search of the backpack, and then you would also have to have a search warrant for the item that's sealed inside that backpack. They fucking just railroaded that shit, including cutting open shit. And then when they found out they kind of had a lot of information on him after illegally going through his shit, they repacked his bag and took him in. I feel like people don't appreciate law because you can't do that shit. You can't. It's not good enough that you know he's the bad guy. If that's your stance. Well, we know he's the bad guy, so fuck him. You know, we can violate his constitutional rights all day long. He's a bad guy. You can't. That's such horseshit. You can't. Law enforcement should be held to a higher standard, for fuck's sake. I'm sorry I'm dropping so many F-bombs. Let's curtail the language. I'm getting upset. I'm getting a bit much, right? So let's curtail the language. A little less F-bombs, all right? All right, let's go. 53. During the search of the backpack, we already covered how they cut it open with the knife. 54. At the McDonald's, police also discovered a clip containing bullets, which was wrapped up in some undergarments. At that time, the Altoona Police Department decided to repack the backpack and take it to the Altoona Police Department for further search and seizure. At no time did APD or other law enforcement obtain a valid warrant to said items. Defendant avers that this search and seizure is illegal and unlawful and in violation of the protections of, you've heard it a million times, 14th Amendment to the United States Constitution and Article 1, Section 8 of the Pennsylvania Constitution. Okay, number 55. We're going strong, all right? At the Altoona Police Department, Altoona police continued to search his backpack, resulting in the seizure of numerous items, including but not limited to, there's some new kind of shit in here, a 9mm handgun printed with printed lower receiver, a mechanized upper receiver, a suspected 3D printed suppressor, a red notebook referred to and titled by the police officers as a manifesto, and multiple handwritten notes. And a full list of seized items is hereby attached in the exhibit, right? When we've gone through the list of items, there was things that showed up in the search at the police office, at the police station, many hours later when the New York Police Department shows up. There's new stuff put in that evidence. By the way, this is why I have a community violation. I have a community guidelines violation, I think, because when I was talking about a new article, a gigantic article about Tish and her desire to beat the feds to arresting Luigi Mangione, I mentioned how there was new items that would suddenly mysteriously show up in the inventory list when the New York Police Department shows up in Altoona, Pennsylvania. Those things are facts. That is not hearsay. That is recorded facts. And yet, I think that's what I got in trouble for, was suggesting that the NYPD could have planted evidence in the backpack that shows up in a late, like 8 hours after his arrest, list of inventory of things that were searched when they got a legal search warrant. I don't know if that's making any sense if you're following through. There was a list of inventory items taken originally, a longer list later on signed by the New York Police Department, and that list has additional items, okay? Those are facts. That's not just hearsay. But I think somebody at TikTok thinks that I'm just making that shit up. No, Thomas Dickey must be making that shit up because that's what he's listing. And the police department must be making that shit up because it's in their police departments on their signatures. They're signing paperwork saying that there's new items in there after the New York Police Department show up. I'm sorry if this is so super confusing. I will try to, when I get back from my vacation and I will try, in Vegas, I'll try to do a long form video where I slow the hell down and cover that Altoona, Pennsylvania thing in depth for my my podcast that I'm making called The Devil's Briefcase. So I'm going to try to do an in-depth Altoona, Pennsylvania arrest bullshit thing where I can slow down and go through it in depth because I'm talking 1,000,000 miles an hour to try to get through this when I got 21% battery. I'm losing the battle, folks. I may not make it. All right, number 56. Again, defendant avers that the search and seizure of the items at the Altoona Police Department, it was in violation of the protections afforded to the offendant by all those constitutional rights. So it's basically also stating that Luigi is asking for all items obtained from the defendant on December 9th, 2024 and the subsequent dates should be suppressed, and the Commonwealth should preclude them from use, which includes but not limited to the false ID, the original identification card seized by the defendant. He wants that tossed out. Any and all items that were listed in the exhibit as things that they found in his backpack should be tossed out. Any and all evidence purportedly belonging to or taken from the defendant should be tossed out. So Luigi Mangione is asking for all that shit to be tossed out. Again, for those of you who claim Luigi Mangione wanted to be caught, sat there for the feds waiting to be arrested with his confession letter in hand, signed, sealed, and delivered to the feds, is now asking through his attorney that I was illegally searched and seized and all that shit you think you have on me needs to be tossed out. Did he do it on purpose? Did he set up the feds? Or did they plant evidence? I'm not going to say which one it went. We don't know. But it has to ask, what the hell is going on here? All right. Wherefore, as a result of the violations of the state and federal constitution, protections which are afforded to the defendant respectfully requests and prays that this honorable court enter an order to A, finding that the initial stop, seizure, and detention was illegal and unlawful and contrary to the laws of the United States and Commonwealth. B, finding that the continued stop, seizure, and detention was illegal and unlawful as being contrary to the laws of the United States and this Commonwealth. C, finding that the arrest of the defendant was made without probable cause or a legal justification and was therefore illegal and unlawful and contrary to the United States and Commonwealth. And D, suppressing and excluding any physical evidence seized and or obtained by the defendant insofar as the same was obtained contrary to the laws of the United States and the Commonwealth. E, suppressing and excluding any and all statements any and all statements uttered by, made, or obtained from the defendant, the same being detained contrary to the laws of the United States. So now Luigi Mangione is asking through his attorney not only to strike all the stuff that you got, but anything I might have said when you hadn't read me my Miranda rights. So maybe that whole, hey, yeah, I'm the guy that did it. Here's my signed confession. All that shit should be tossed out. All of it should be tossed out because it was an illegal detention. Suppress and exclude all evidence seized as a result of the warrantless search of the defendant and his property, including but not limited to the original identification card seized by Altoona, as well as all items in the exhibit. Suppress and exclusion of any and all evidence that has been seized as fruit of the poisonous tree. All of that can't be used because it's fruit of the poisonous tree. That all the shit they've got on Luigi Mangione, all of that shit they got on him is obtained illegally. By the way, we're going to get into a buccal swab if I have any time. That buccal swab and DNA that they took from Luigi Mangione. Fuck! I don't even know if I can get through this all. I don't have enough battery power, enough energy, and enough time. All right, let's try to get through this. Number 60. Said search resulted in the confiscation and seizure of numerous items, including but not limited to note papers and or other notes purportedly written by the defendant. Purportedly written by the defendant. So this wording is almost suggesting this may not have been written by Luigi Mangione. What he's saying is this: some of the stuff that needs to be thrown out is the seizure of numerous items, including but not limited to note papers and other notes purportedly written by the defendant. Laptops, computer chips, thumb drives, journals, and ledgers. Said search also resulted in the confiscation of numerous items listed in this exhibit down below, Exhibit B. The above-named confiscation and seizures were done without warrant and without authority. No exigency, it's a big word for me, supported the warrantless search of the backpack or no other containers. So in other words, just everything is basically saying it was illegal. Here's about the DNA. I'm going to have time to do the DNA. We're at 21% battery. I'm still here. Point 66, while illegally seized, arrested, and detained, the defendant was provided food and soda. So Luigi Mangione was provided food and soda in the Altoona Police Department, right? So let me continue. While illegally seized, arrested, and detained, the defendant was provided food and soda by the Altoona Police Department at the Altoona Police Station. The purposes for the purpose why they gave him food was to obtain DNA from the defendant for further investigative purposes. Insofar as the defendant's detention was illegal for reasons set forth, and any and all DNA samples, profiles, etc., were poisonous fruit of the poisonous tree, obtained in violation of the protections afforded by the defendant by the Constitution of the United States and the Commonwealth. So basically, it's one commenter on my threads on my video said, and it indicates that he was law enforcement as well. He said, this is a common law enforcement tactic. Doing basically, hey, let's be nice to you. Are you hungry? Are you thirsty? And then they hand you something that you get your fingerprints all over, and then they use that to go run your fingerprints. Here, have a bottle of water. Put your fingerprints all over there. Have a cup, put your fingerprints all over that. Have some food, put your fingerprints all over it. We're not telling you we're taking DNA samples. We're being nice. We're giving you something. Look at what great guys we are. Is there something that can make you more comfortable? Can you touch a bunch of shit for me and give you your DNA? That's a tactic law enforcement uses frequently. Some people would call that sketchy as shit. Other people just call it a good law enforcement tactic. Anyways, wherefore the defendant prays and requests that the court suppress any and all DNA samples and profiles. Once they have his fingerprints, those fingerprints can be transferred to other things. Now, I know that's crazy. Law enforcement's not going to transfer fingerprints. It's not like law enforcement said originally that they had partial smudges on the bottle, but now all of a sudden, after they got Luigi Mangione's fingerprints on a cup in Altoona, now they have great fingerprints of Luigi in Newark. It's not like that happened. But anyways, I digress. The Commonwealth, for reasons previously set forth, the defendant prays and requests that the court grant relief by quashing and dismissing the charge of forgery against the defendant and granting the relief that justice may require. Okay. 71. All previous paragraphs through 1 through 70, inclusive hereby, incorporate here and set forth within. Basically, the defendant has been charged with a firearms charge not to be carried without a license. Here's an interesting thing, and I'm going to go short on this. I'm going to go short because I'm running out of time, I'm running out of breath, I'm running out of all these things. Is basically, they're also arguing a violation of his Second Amendment firearms right. Now, I'm going to be brief on this because a lot of you can't stand firearms. I understand that. It's a super controversial thing in the United States, but there there are those who believe that we have a Second Amendment right to bear arms. That's one of the things that the attorney's actually arguing, is that it's not a violation of for him to have a firearm because it's protected under the Second Amendment. Okay, that was interesting for me to see that they would even suggest that, but they're literally saying that they're going to argue that him having a weapon isn't illegal. That he has a constitutional right to have a firearm per the Second Amendment, the right to bear arms. Now, again, I don't want to get into that. That's a whole ball of wax I don't want to get into right now. But it's interesting enough that Thomas Dickey is bringing up that the firearms charge also is bullshit because it's a violation of his Second Amendment rights. He has the right to bear arms. So therefore, they're going to argue against even the gun as well. So and then they're talking about now the tampering of weapons, or tampering of records. This is the production of the false identification. So they're saying that they want that tossed out. We already know that. We're going to skim through and try to get to the end because I need to wrap this up. I need to go visit with family. Really, I'm on a family vacation. I need to go visit with family. Let me try to wrap this up. Thanks, by the way, for everybody hanging out with me tonight. This has been super fun. Yes, and Tish was putting immense pressure. And I got my first content violation, community violation again just recently. I've had a clean account. I've got a tiny little mar for mentioning Tish in that big article. So I got to be careful about Tish because I already got spanked. So let's see if we can get past that. I've got an appeal in it. Let's hope we win that now. So the charge of possesses an instrument of crime is unconstitutional insofar as it is contrary to the right to bear arms. Okay, we already talked about that. So they're going to argue the gun charge that he has the right to bear arms. Again, that's a whole. I'm not going to get into the whole right to bear arms issue tonight too much. So on December 10th, 2024, on or about 12:17 p.m. This is new information, new names, new times for me. New times for me and new information. Listen to this. On December 10th, this is after the arrest in Altoona, 2024, on or about 12:17 p.m., Honorable Judge David Consiglio issues a search warrant which defined the items then seized as property of Luigi Mangione, namely a pair of light gray underwear, black in color pair of socks, blue jeans, and a blue Columbia thermal, to store and ultimately transfer to the custody of the New York Police Department. Listen to this, people. Listen to this. So on December 10th, Honorable Judge Consiglio issued a search warrant to basically take Luigi's items and transfer them to the New York Police Department, which include his light gray underwear, a black color of socks, a pair of blue jeans, a blue Columbia thermal, and store those and transfer them to the NYPD. Huh, that's interesting. Describes the premises and or person to be searched as property of Luigi Mangione, date of birth 5/6/1998, currently being stored by the Pennsylvania Department of Corrections and to be transferred to the custody of Blair County Sheriff's Office and then ultimately to the NYPD. Nice of them. Okay. That's going to be a discussion for another day. Number 88, the affidavit. So the affidavit for arrest or probable cause to bring Luigi Mangione to New York, basically they're saying the issuance of the search warrants violated Luigi Mangione's 14th Amendment of the United States Constitution and Article 1, Section 8 of the Pennsylvania Constitution. I'm getting more and more sloppy with that. But they're basically saying the search warrant that the judge signed off on the day afterwards, transferring property now so they can take him to New York and bring him to New York and extradite him to New York, all of that was illegal as well and a violation of his constitutional rights. Which, not a surprise. Okay. On or about 12/9/2024, at around 6 p.m., so this is the day of the arrest, at 6 p.m., Honorable Judge David Consiglio issued a search warrant which identified the items to be searched and seized as electronic devices, including but not limited to cell phones, laptops, firearms, all firearm magazines, ammunition, silencers, identification including U.S. passports, driver's license, and all transportation ticketing items, handwritten notes, transactional receipts, buccal swabs, that's cheek swabs, getting your DNA, and clothing worn by the person of Luigi Mangione. So the day of his arrest, later on, after this judge signs off on this search warrant, including taking a buccal swab of Luigi Mangione's cheek, all of that happens, and then later on, the New York Police Department sign off on the new inventory. They sign off on it. This is sketchy as fuck, people. If you're not paying attention, go and look at these documents. Look at the exhibits. Look at the 3 signatures at the bottom of Exhibit B in this document. If you can find this document on LuigiMangioneInfo.com. His lawyers have provided links to this. If you look at the list, at the end of the inventory sheet, taken late that night, after this judge signs off on a search warrant, another search of Luigi Mangioni's backpack that they obtained illegally from the arrest that morning is conducted. After the judge signs off giving an official search warrant, 3 people sign that document. Who signs the list of inventory items? The 2 detectives police officers from Altoona, Detweiler and Fry, and a New York Police Department officer, who, by the way, has allegations and lawsuits that have been settled with the New York Police Department for $75,000, including things like illegal searches and seizures and arrests and allegations of planting evidence. But that's just an aside. I don't want to get myself hammered for mentioning that. But those are all things you can look up and find out. I don't know if that's making any sense. I'm moving so fast. I'm at 20%. I got to get 20% battery power. I'm almost done. Let's get through this. The affidavit states the affidavit fails to state probable cause. So they're issuing a search warrant. This judge is issuing a further search warrant of Luigi Mangioni's possessions to basically get New York to be able to tie Luigi Mangioni and take him to New York without probable cause. And so there's all that. And I think we can kind of wrap up. I'm trying to see. There's probably another big point. Oh yeah, there is a big point. Fuck the whole thing. It is alleged that during the arraignment, this is big. Do you remember the moment where Luigi Mangioni supposedly was in court and they're arraigning him and they're telling about his things and what they have on him, and they list $8,000 in U.S. currency and $2,000 in foreign currency, and Luigi Mangioni makes some kind of comment and says, by the way, I want to make a clarification. I don't know where that money came from. That has to have been planted. That's what I think this is talking about right here. That happened, right? Remember that happened. Number 97. It is alleged that during the arraignment before Magistrate Ben Jones, the defendant made certain statements. Number 98. Defendant had previously invoked his Fifth Amendment right to remain silent as protected by the Fifth Amendment of the Constitution of the United States, as well as Article 1, Section 9 of the Pennsylvania Constitution. Said statements were obtained in violation of the aforesaid protections. In other words, they're saying because Luigi Mangioni already said that he wanted to remain silent, him making statements of anything like that should be stricken. Now, I don't know how that works exactly, because, he was told of his rights and then he said something anyways, but they're saying that he basically wants those things stricken. This comment about, hey, I don't know where that money came from, it had to have been planted. The purported meaning of the statements is based on speculation by the Altoona Police Department. So it may not be the statements about the money in the bag, but it did say these were statements made during his arraignment. So that's when we know that happened. Again, I realize I don't sound real coherent here. You're probably not understanding what I'm saying. I may have to do a longer deep dive on The Devil's Briefcase, my podcast. I'm at 19%. I got to get through this, people. All right, so let me finish this. Basically, the defendant, Luigi Mangioni, respectfully prays and requests that the honorable court suppress any and all statements. So Luigi not only wants the items that were illegally obtained, but any statements he made to be tossed out. Any statements he made needs to be tossed out. That's what he's asking. The Altoona Police Department illegally seized a notebook allegedly containing numerous personal writings that covered a plethora of personal experiences of the defendant. A member of the Altoona Police Department improperly and without justification labeled these writings or notebooks as a manifesto. This is huge. The word manifesto is meant to make somebody look like they're guilty. Nobody writes a manifesto except for somebody who's doing some kind of crime. They've done something horrible and they're writing their manifesto, explain to the world why they did these horrible things. The use of the word manifesto was an invention by an Altoona police officer. This is something that was brought up before and is brought up again. The entire wording about a manifesto was made up by an Altoona police officer. They were just simply allegedly notes written by the defendant, not a manifesto. Not a manifesto. That was a word used by the police department. The use, this is continuing straight from Dickey's report, 103. The use and characterization of the defendant's personal experiences and writings is incorrect, improper, and without justification, and has no probative value. The defendant believes that the characterization was done so solely for the purpose to prejudice the defendant and put him in a negative light before the public, all in an effort to prejudice any potential jury poll. So what are they saying? They're saying the same thing I just said. The Altoona Police Department told everyone in America that he had a manifesto on him to prejudice America against him. He's a bad guy. He confessed to doing it, and he had his manifesto on him. Luigi Mangioni never had a manifesto. And he's telling you here through his attorney, I never had a manifesto. And the entire use is the same thing I've been telling you, and you figured it out. It's not like I'm telling you something you don't know. You had figured it out. So don't think I'm trying to take credit of that. I've been saying all along, the use of the word manifesto was purely prejudicial. They wanted to prejudice somebody by thinking he must be a bad guy because not only did he confess to it, but he had a manifesto. And that word manifesto is something they made up. And he's asking for them to strike the word manifesto and all that bullshit related to a manifesto because it's complete crap. He never had a manifesto. That's the end of that. That's the end of that. So we are done with my verbal vomit for tonight. I want to say again. We are down here in Vegas, my wife and I, to meet her half-sisters who she met for the first time today, face-to-face. That is going well. They are out there right now socializing and having a great time. I'm going to now join my family. If you want to watch at all what's happening with my family and the things that we're doing in Vegas, watch my YouTube channel. I have a second YouTube channel now, because I want to keep these private videos about the family. Not private, but I want to keep them separate from the main channel. So in other words, follow Devil's Advocates on YouTube if you want to get my long-form videos that are just about Luigi Mangione and Brian Koberger. If you want to see some personal behind-the-scenes story about myself and how I got into true crime and my wife and how she met her family, check out our second channel, Devil's Advocates Backup. It's a second account. You can find that, and you can also see behind-the-scene things about my wife and her sisters and learn about our story if you're interested to know the man and the women behind the Devil's Advocates. Again, this video will be posted a couple hours after this live, God willing. I should never say God willing. This is a bad choice of words. All things considered, we will hope that we will have this video up in a couple hours on my YouTube channel so that you can watch this again and slow it the hell down because I talk at 1,000,000 miles an hour. Everybody, please have a good one out there. Stay safe. Thank you for tuning in to our live. Thank you for being here and supporting this with all the great likes and all the support that you guys give us. Have a good one, and I'll catch you when I can catch you again.